All right. Hi, everyone. How's it going? This is immigration attorney Moumita. Thank you so much for joining me on this Monday evening live. I am here to answer your immigration questions and discuss any immigration topic that you have as much as I can. So for those of you who don't know me, my name is Moumita Rahman. I am an immigration lawyer. I have been an immigration lawyer for the past 11 years, and I love what I do. I have been working with clients all over the US. So if you ever need a consultation on your case to discuss what your options are, give me a call. All right, so let's get into it. So if you're joining me, thank you for joining live, and please post any questions that you have. So the majority of cases that I do are humanitarian cases. The majority of people that I work with tend to be folks who have not entered legally and have been told by many other attorneys in the past that they simply have no option to legalize your status. But what happens is this: most attorneys do not take the time to look into certain cases that can help people get a work permit and a green card, even if they entered illegally into the US, which, believe it or not, there are actually several different types of cases that do not require you to leave the US in order to fix your status. And this is what I like to work on. This is a lot of my case types, and I relish what I do because really there's nothing better than being able to give somebody that hope and to be able to help families stay together and for people to have opportunity. So if you do have a US citizen spouse, or you have a child who's at least 21 and you've been waiting to hear the news, waiting to find out what it is that you can do to fix your status, give me a call, 212-248-7907, because this is what I do. I will take a look at your case to see what you qualify for. And if you don't qualify, then we will figure out a plan to keep you protected as much as possible. Another thing that we have been hearing a lot of my cases deal with people whose spouses, whose US citizen or green card holding spouses, do not want to help them fix their papers. If you are married to a US citizen or to a green card holder and they are refusing to help you file for your paperwork, or you have already filed your paperwork and now they're saying, I don't want to go to the interview with you unless you do all these things that I ask you to do, or no, I'm going to call ICE on you. I'm going to get you deported. I don't care what happens to you, or I'm going to move halfway across the country and you can do whatever you want. Good luck to you. This is when you really need to talk to an attorney to find out what your rights are, because you do have rights. Even if you're an immigrant, even if you're undocumented, even if you entered illegally, you have rights. And I want to help you find out what is possible for you. Now, this is why a consultation on your case is so important, because what I do here live, I cannot go into the details of your case to make sure you qualify for everything. That's why when you book an appointment with me, I have my set of questions that I ask to see what you're eligible for. All right, so that's it. I'm going to go ahead and start answering some questions. Thank you to everyone who's joining me. All right, let's see. And also to those of you who've not watched me before, I am live streaming on YouTube, Facebook, Instagram, and TikTok. So please have a little patience if I can't get to your question. And hello to everyone who is saying hi. All right, I have a question from Tatiana. Will I get denied if I withdraw my I-485 application even though I have not received a biometrics appointment? Tatiana, thank you so much for your question. So if you have filed an I-485 and you don't have a decision yet, if you deny it, yes, you will certainly get denied. A withdrawal of an application basically means that you're telling the government that you will, you're basically taking it back. You basically want it to be as though you never filed the application in the first place. So if you've already put in your application for a green card and you withdraw it, then you may be denied. But that also depends on a couple of other things. So for example, if you are filing your I-485 with any sort of humanitarian type applications, that will not affect the I-485, those applications. But if you're filing it based upon marriage to a US citizen where you're filing an I-130, then it may definitely cause a lot of things to go wrong. And if you withdraw your I-485, then if you have attached any work permit applications to that, those would also not get processed. Okay, I hope that helps. All right, from Instagram, I have a question from Karen Ansa, who's saying, I got married in 2019 and had a baby in 2020. Unfortunately, I lost my passport, but have soft copies of my passports and visa. My husband is a non-filer. We wanted to know if I can get a green card. So Karen, thank you for your question. I'm assuming that when you say your husband is a non-filer, you mean that you're talking about, taxes. Taxes, if you're filing, the regular marriage green card case, not the other ones, the regular straightforward adjustment of status case, which you can only do if you have a legal entry into the US. You do have to file taxes for it. You do have to file taxes, and you do have to show proof of your legal entry into the US. If you don't have that, give me a call. We can figure out how to best prove it. You can order your entry records from Customs and Border Patrol. But if you need help, give me a call, 212-248-7907. Even the regular case is so difficult to do these days, and I do not recommend that you do it without a lawyer. Unfortunately, I had somebody who called me, maybe 2-3 years ago to do the case, and they decided to do it on their own. And after these 2 years have gone by, their case has gotten denied, and they've come back to me again for help. My fees have gone up quite a bit because the work of the case is so much more. Even though Trump is gone, the work on these cases has not gone down. It's not going to go down anytime soon. And, it's going to be a very difficult time. They don't have a work permit. So definitely talk to a lawyer. We have years and years and years of experience that really can make a difference in your case. All right, 212-248-7907. And thank you for your question. All right, I have a question from Slater versus the World. I have a question. Where can someone start doing their green card application if they have DACA? Slater, thank you so much for your question. So if what you're referring to is the Biden proposal for immigration, right? That's exactly what it is. It is just a proposal. There is no law yet. There is no law that actually gives DACA recipients a green card yet. It is something that they're hoping to get passed through the DREAM Act that was introduced. And also, probably they'll fight for it pretty hard, but it still has to go through Congress. It still has to get approved. Once it's approved, then we have to see what they actually put in there as requirements for eligibility, and then we'll find out. But, as soon as I find anything out about DACA folks, I will definitely let you know, because I have a lot of DACA clients, and we want to make sure that everybody gets their green card if possible. All right. I am Zobi is asking for an I-129F. Does the processing time 6 to 9 months begin after you receive confirmation from USCIS? Very good question. Your processing time, no matter what case you file with USCIS, starts from the date of that they say is the date of the receipt, or the priority date is another way that they call it. So if you mail your application on January 1st and they receive it on January 2nd, but you don't get your receipt for another 2 months, which is happening these days, it's taking like 2-3 months to get a receipt. Even if your receipt date is March 1st, as long as it says that USCIS received the case on January 2nd, that is the start time for your processing. I hope that helps. Someone's asking, I was born in Wakanda. How do I apply for citizenship in the US? Thank you. Good luck. I know where Wakanda is, and I know it's fictional. Thanks. Let's see. What is a better way, from Noelia, what is a better way to get my husband his green card if he entered illegally at 4 years old? Noelia, thank you so much for your question. So if you're married to somebody who does not have a legal entry, right? They do not have a legal entry. They've been here for a very long time, and you are a US citizen or a green card holder, and you're wondering how to help your spouse. Well, you're going to have two options. One, you can leave your spouse can leave the US and do what's called a perdón or a waiver, but that is a very risky thing. And I actually have a different way that I do my cases. I try to see if my clients qualify for a different sort of case that does not require them to leave the US. So even if they have an illegal entry into the US, it may still be possible for them to get their status fixed without leaving. So you can give me a call, 212-248-7907. This is what I'm dedicated to helping people with. Okay. So ABC MTZ is asking, if somebody has a felony, can they get a visa for something? That's an interesting question. So if somebody has a felony, does that disqualify you from a visa? I'm going to say that the short answer is maybe. Normally, in order to get a visa to come into the US, you need to, you cannot have any sort of disqualifying criminal history. And it will really boil down to what you were charged with, what the final conviction was, and especially if it's overseas, it might be, you might be in a little bit more hot water, because when you're overseas, the consulate The consular officer at the visa office is basically going to interview you, and they have a lot of discretion. They have a lot of discretion over who to approve for a visa, who to give the special great permission to. And I would say it's probably going to be difficult. You can contact me for your case, okay? I hope that helps. All right, I'm going to switch over to my YouTube channel. Nicholas, thank you for your question. Nicholas from Trinidad, can you self-petition for an H-1B visa, or does a company have to petition on your behalf? I am currently an OPT starting a new job soon. Nicholas, thank you so much for your question. And that's actually a very good question, something that I get a lot from people who are students here, who are on OPT, who are looking for a way to stay in the US. So H-1B is something that you've definitely heard of, but here's the thing. For H-1B, it is not a self-petition. You need to have an employer petition for your case. And one more thing is that only the employer can pay the attorney fees and the government fees for your H-1B visa, okay? It is actually in the law. And, if an employer pays, makes you pay the fees, or you agree to pay the fees, the employer can actually get into a lot of trouble. All right, Nicholas, I hope that helps. Lisa Witten is asking, help, I need to know what is the best form to start with to get my son-in-law legal. Lisa, thank you so much for your question. What I would recommend to you is, you can't just do a form to get somebody legal. You first have to see what forms the person would qualify for. I would recommend having your son-in-law give me a call, 212-248-7907. I've got my staff standing by right now. Josue and Abel are standing by to take your call and book you for an appointment for your case, okay? The only way that we can find out what a person can qualify for is, after going through a set of questions to see what their issues are. So I would recommend you give us a call. All right, let's see what else we have. And thank you to everyone who's watching. Patty Diaz asking, do you look up a person's case until you take it on? So it will, Patty, thank you for your question. It will really depend on the person's case. Sometimes, especially if you already have another attorney involved, I may need to see what has happened, or if you filed other applications in the past, I might need to see what has happened in your case. Usually, if a person has already had an immigration history where they have filed paperwork with the government before, we will usually order those files. It may take us some months, but I want to see what the client has in their file, before we go in front of immigration. But it may not usually prevent me from filing an application, but I will usually look things up. All right, let's see. Andrea Gallo Gomez is asking, I met my husband in Mexico after he signed his own removal order. I filed an I-130 in 2018 and still haven't received a response. What are my next steps? Andrea, thank you so much for your question. So if you filed your I-130, in 2018, and I-130 is the petition that most people have to start their family-based application with. Now, an I-130 can be filed for a spouse of a U.S. citizen, a spouse of a green card holder, parents of U.S. citizens, and siblings and children as well of green card holders and U.S. citizens. You have to usually file this in order to establish the eligibility for a visa or for other adjustment of status applications here in the U.S. I would say that if you have filed your application back in 2018, but you haven't gotten a response, you don't have any information at all whatsoever, something might be wrong. You should have at least received a receipt from USCIS on your case, giving you your case number. And keep in mind, if your relative falls into a preference category, then your I-130 may not get approved for quite some time. But if your spouse, if your relative is an immediate relative, which it sounds like they are, Andrea, it sounds like maybe you're a citizen, and that means that your spouse, any spouse of a U.S. citizen, is considered an immediate relative. Your I-130 would ideally have been approved by now, but what you can do is give me a call, because we can help you look into the case. Possibly, one thing that you can do on your own is contact your senator in your state for assistance with your immigration case, and sometimes that helps. Okay, I hope that helps, Andrea. Parminder Singh is asking, if asylum is pending marriage to a U.S. citizen, can I travel emergency to my country or no? Please, thank you, Parminder. Please give me a call. Please contact me so I can take a look at your case. All right. So Eva Edith is asking, what kind of visa could I get if I'm a DACA and I'm a domestic violence victim? Ava, thank you so much for your question. Okay, so if you are a domestic violence victim, there are actually possibly a couple of different, maybe even 3 different options available for you. If you are married, to a citizen or a green card holder and you have suffered this, definitely give me a call. All that you need to show, to qualify right now, obviously if you've suffered something, and by the way, what I want you to know is domestic violence can be physical and emotional, okay? So definitely give me a call if you are married to a U.S. citizen suffering this. There may be a way for you to get a green card through that. Also, there may be a way to get a green card, if you have actually filed police reports because of this domestic violence and, you are cooperating with law enforcement, okay? That is called a U visa. Additionally, if you have been in a relationship with someone, where you have essentially been treated like a servant, forced to work, maybe your spouse will actually, or your pareja will actually make you, force you to work in certain job and then take all of your wages. This is actually a very special situation that can also help you get a green card. Obviously, no one should have to suffer any of these things, but these are some of the humanitarian type cases that can actually help you get status, even if you entered illegally, even if you have DACA, even if you have no other, if you're not married to somebody who's a citizen, okay? So definitely give us a call. All right. So let's see what questions I have. Someone's asking, is it true that you can get married or pregnant while applying for papers? There's no prohibition generally if you get to not get pregnant, or a requirement to get pregnant if you're applying for papers. But of course, if you're applying for papers based upon a relationship, based upon a marriage, then having kids will usually help because it's usually proof of your marriage. All right. Okay. All right, Esther is asking, my fiance is worried that if he marries me, he won't be able to apply for a citizenship. He is a DACA recipient and I am a US citizen. Esther, thanks so much for your question. So if your fiance is worried he won't be able to get citizenship, I don't see what that fear would be based upon, okay? Because if you're a US citizen, you would be able to help him get his papers. And if he's DACA, then he probably doesn't have any other way right now. Maybe he's worried about the fact that the Biden proposal is proposing green cards and citizenship for persons who already hold DACA. But what I would say is, if you're already about to get married, you're a US citizen, they hold DACA, go ahead and get married and start your paperwork. It's not going to cut off any eligibility. And besides, they're going to be eligible to become a citizen after they've held their green card status for 3 years. Okay, I hope that helps. Okay, Patty Diaz is asking, what's the difference between a 10-year bar and the 10-year permanent bar? Is it the same? Patty, thank you. That's actually a very good question. The 10-year bar and the permanent bar are actually 2 different things. All right, the 10-year bar is something that that you trigger if you have been in the U.S. for more than 1 year illegally, and then you leave the U.S. All right. So if you have been in the U.S., unlawfully for 1 year or more, and then you depart the U.S., you trigger. Basically, it's like a bar, right? Like you trigger this 10-year bar to coming back, which is why some people qualify for something called the perdón, or the waiver, the I-601A waiver. If you do the I-601A waiver before you leave, then you're basically asking for like an advance perdón or pardon of that 10-year bar, okay? The permanent bar is something that's actually totally different. The 10-year bar is something that is triggered when you have had at least 1 year of unlawful entry, presence in the U.S., and you leave, and then you enter unlawfully, or you've been deported and you enter unlawfully after April 1st, 1997. Okay, that's the permanent bar. You can't even, you cannot fix the permanent bar outside. There's only certain case types that are available inside the U.S. This is actually what I focus a lot of my cases on, is fixing the permanent bar for people who are here in the U.S., who have been told by everybody else that, the only way to fix, to get over the permanent bar is to just leave for 10 whole years, okay? So the 10-year bar, you can actually fix with a waiver. The permanent bar, you cannot fix you cannot fix outside the US. You can only really fix it if you qualify for certain cases in the US. That's what I qualify for. So if you've ever been told by somebody that, you can't fix your status, even if you're married to a US citizen, or even if you have adult US citizen children because you've got a permanent bar, give me a call, okay? All right, everyone, so that's it. I'm gonna go ahead and go. Thank you so much for joining me today. I really appreciate it. Please give me a like, please give me a follow, subscribe to my page, leave me some comments on my videos, and I hope to see you all next time.